Welcome back to the House Judiciary Committee and continuing testimony on S12. And we'll turn to Susanna Davis. Thank you very much for being here. And identify yourself for the record and proceed.
Thank you. Good morning. Buenos dias. I'm Susanna Davis, Executive Director of Racial Equity. Thank you all for inviting us to testify on S12. My comments today are largely going to mirror those that I shared with the Senate committee when this bill was on the Senate side. And I do recognize that since then, the bill and the conversation have deepened a bit, which is really hopeful to see. But I think that there's still a lot of room for continued improvement. And so I'm hopeful that we can share with you some considerations that we hope the committee will make as it deliberates the bill. My comments are going to feel a little bit disparate because there are a lot of different components to this. You've heard a lot from other entities already, so I don't think that I have to go into too much detail. You've heard from those subject matter experts, but we do just want to touch on a few different things that are lighting up for us in this bill. The first couple of points are really more general. I'd like to start by saying really clearly for the record, we believe that expungement should remain on the table more broadly than it is represented in this bill. If we say that we don't need a record, we don't need to keep it. I made this joke on the Senate side and they did not appear amused, but I'm going to say it here, which is this to me feels a little bit like the running joke that they make about us millennials about keeping the cell phone box, even though we know we're never going to need it again. I think that we really have to have a conversation about it. If we say that there is information that's no longer going to be germane to a person's day-to-day life, if we say that there's information that we're willing to let go, then I think we have to demonstrate that by really being able to follow through with that. We also just want to note that I know we've heard a lot about the different definitions and in this conversation, not just here in Vermont, but in other jurisdictions as well, a lot of these terms are used interchangeably. And we really want to highlight how important it is that we come to a solid understanding of what we mean, because people's lives, not to sound dramatic, but it is very true that people's lives really are going to depend on us having a clear and shared understanding of what terms we're using. And that's going to include sealing and expungement and what does it mean to retain something or to keep a log. That kind of takes me to my next point, which is we really need to talk about a records management strategy. We have some staff on our team in particular who are very passionate about records management, who came to us from records retention and records management profession. And so they've really given us a lot of insight into the differences between policy language we're seeing in the bill versus how actually this gets operationalized in real terms. It's our strong suggestion that if you haven't already, that you do hear from the state archivist and the chief records officer. We work a lot with Tanya Marshall. We appreciate everything that she brings to the state and all of the information and the expertise she's shared with us. And we think that it would be really great to have her come in and just level set on public records, the Public Records Act, the exemptions, et cetera. Again, we want to make sure that we're not conflating different things as we talk about these terms in the policy language. I also think that this could address some of what the Sheriff's Association testified to regarding who the actual custodians of records will be under this kind of a process. So really having an understanding of what the records management strategy is going to be is important. One thing that came up on the Senate side, I know that this isn't necessarily something that is up for debate right now, but one of the things that was discussed that we just want to say we still support is the concept of giving people a hard copy of their records as a matter of course. We think that that's important. It's something that we highlighted in a report that we did last year on access to carceral records of oneself. I think that we shared that report with this committee, but if not, we'd be happy to after this testimony. We want to make sure not just that the procedural elements of sealing or expungement or what have you are fulfilled, but also that people are, as a matter of course and unprompted, able to receive records that pertain to them. We see that as an important part of not just transparency, but also as access to justice. In line with that, we also think that it's really important that whatever process this bill results in, that there be a set of very clear, very comprehensive, plain language materials developed so that the public can genuinely understand what is at play for them. Impacted individuals really need to be able to have a clear and realistic understanding of what are the amendments, and what kinds of access are going to be had to their criminal histories. And when we say plain language, that's actually a term of art. Generally, it'll depend on who you ask, but a plain language rewrite of a document may span anywhere between a third to an eighth grade reading level. I think generally more commonly accepted might be eighth grade reading level. That's going to be really important, not just for those of us who have very little time to read technical documents, but also for people who may have developmental disabilities, or just for any lay person who hasn't been watching hours and hours of this testimony to really understand what's happening. So we strongly suggest that there be a plan for how we're going to develop plain language materials so that everyday people can understand this process and what it means. And we would refer you to the Vermont Developmental Disabilities Council for assistance on how it looks, what it looks like, and what process you could go through to develop plain language materials. Or perhaps that there be a provision added to this bill that directs someone to work with the council and other entities to make sure that plain language materials are developed and that they're available from a number of different sources so that there's a no wrong door approach to getting the information, whether you're visiting the court's website or whether you're somewhere else with a tablet in DOC or what have you. We talked a little bit about employment discrimination in the Senate side. I don't really think that that is currently at issue in this bill. But I will share with you all what I shared there. And I think it's out of a bit of a paranoia. Sometimes a provision may get dropped and you think you're done with it, and then it resurfaces again later on. So I want to make sure we're on record saying it here too. It's really important that if there is consideration about when these kinds of records could be used in employment situations, that we consider, again, the most minimally invasive and most upfront method of having that carve out. And we want to quote Elizabeth Westrope, who wrote in the Journal of Criminal Law and Criminology, and I'm going to directly quote her here. She talks about a statute that explicitly bars employment discrimination based on criminal history records is going to be important. And that if there are employers who list qualifying offenses, that there be a requirement that they do so upfront and implement a time limit past which employers cannot consider old offenses. This is really important. It helps to avoid decisions that may be arbitrary or changing on case-by-case bases when it comes to employment. And the reason that we're so concerned about that, of course, as you know, employment discrimination is a very real thing. It manifests in different ways, but race tends to be one of the factors upon which employers rely most when discriminating against applicants. And the use of things like criminal history is one of the tools used as a bludgeon against applicants of color to disqualify them from jobs that otherwise they would be suitable for. So again, I'll put that there. I know you haven't been having a conversation about that, but I want to make sure that that's not necessarily lost in case that resurfaces. We agree with the Defender General's office. Keeping the expungement for deferred sentencing is a good thing, although you've already heard from Marshall about all of the limitations around that and the ways that that could have been strengthened. We also, just as a more pragmatic matter, have really looked at who externally, which entities are going to have access to these records. We know, of course, that the judiciary still does maintain that special index of sealed and expunged records. And so if there is that log in existence, we just want to make sure that that is not treated as an access point that could still otherwise be unduly prejudicial to people. That does include information about the offense being sealed. And so making sure that we manage not just access to the direct record, but also to any other ancillary forms of information that could be used to build a profile about a person that contains information that we've ultimately determined is sealable. And again, I would, of course, defer to the courts for their expertise on that piece. When we did our report on access to carceral records of oneself, we reached out to a number of other jurisdictions around the country. The three who provided us the most depth of information and the most some of our more useful research came from Pennsylvania, New York, and Michigan. And what we learned from those entities, one of the things that was really clear from all of them was that it's very important that any participants who have access to these records or who are going to be steps along the way to a sealing or expungement process need to be on the same page regarding the technical aspects of their systems working together. In other words, if you have a jurisdiction that has disparate systems, that is to say, where information is going to be found in multiple different data sets or different systems, you want to make sure that everyone understands what's expected of them, both looking at the spirit of the law, but also from a technical perspective. It's often the case that one entity might do its due diligence in eliminating a record or stealing it, but another one may not have taken the same steps. And so what we've done is we've created a vulnerability that might potentially end up keeping a person's records accessible when they should not otherwise be. Along the lines of that, we want to talk about upgrading systems and what does it really mean to have the technological components in place for this. If we're going to have these records following people around for the rest of their lives, how long is long enough for that continued punishment? And there is a term devised for that, digital punishment, you've likely already heard. We know that there are certain things that are outside of the state's control necessarily. Like, for example, we can choose to do sealing or expungement or any combination of those things and apply that to a criminal history record. But while that might represent our best effort at trying to protect people and helping them be able to get a fresh start, we live in a digital age. And for that reason, information still likely exists in other places, for example, online. And so in some senses, people may still be experiencing the long-term and the residual effects of that, the existence of that record. That's what we refer to when we talk about digital punishment. And so there are some things that do live on in perpetuity. And again, to some extent, the state cannot control that. We don't regulate background check websites that individual people can pay to get this information from. Recognizing that, however, we do have an opportunity to limit what comes into their purview in the first place and what kinds of information they end up having access to. So just being really careful about what is accessible to the public and making sure that we're providing other people ancillary protections against the misuse of that information. Kind of like what we talked about earlier about employment discrimination and whether or not these kinds of records accessible through other sources can still be used to cause people the kind of harm that we're trying to protect them from through these systems in the first place. Let's see. Oh, yes, we oppose roadside access for reasons you could probably understand already. I question whether that's actually helpful in a law enforcement context. I recognize that our peers in law enforcement would probably say, yes, it's helpful and relevant. Again, you know, I think that sometimes there's a lot that we can assume and that we think we can extrapolate based on a person's history. You've already heard from DGO about the reliability of those kinds of data, particularly as years go on. And so in some senses, we may be priming ourselves to make judgment calls during roadside stops or other encounters in the present day that may not actually be reflective of what the actual threat or perceived threat is before us. So I want us to be really careful about which circumstances we think are really helpful to be able to understand those things. I'm also curious to know what it means for a situation to be really emergent or an emergency, the amount of time that it would take us to access some of these records in situations that are considered emergent or time sensitive. Again, what is really the utility of being able to access sealed or expunged records, and who are the people who are going to need to have access to that? I do want to talk about who are the people who are going to have continued access and tie this back with another piece. I haven't heard a lot about it, but the risk, the liability that comes with broad access. The more people on your list of people who have access to sealed or expunged records, the greater the risk is for misuse or breach. Now, that in itself carries a financial cost in terms of risk management. So I think when we think about what is it going to cost us to retain records, perhaps unnecessarily for a long amount of time, the greater the number of people who have access and the longer the access period, those two things together create a much larger risk in terms of risk management for the potential for misuse and breach. And we don't have to look too far in history to see state employees breaching confidentiality, like handing over records to ICE for things like driver privilege cards. So the assumption of good intentions and the assumption of good faith use is probably something we don't necessarily want to take for granted. And because of that, we have to consider the legal and financial risks that we run the more people we let have access and the longer we let them have access. In addition to that cost, there's also another cost of actually storing data. It costs us money as a state to store information. And so again, when I think about what is the return on the investment of engaging in this kind of a system, how long do we want to retain things? We also want to consider those hidden costs that perhaps are not front and center in the policy discussions, but in terms of operationalizing it, there is absolutely a cost to digital storage. And so we have to make sure that whatever entities are tasked with retaining information, that they're properly resourced in order to do that, and that resourcing is still in the interest of the state to continue expending. Let's see, I want to communicate our disappointment that the list of qualifying misdemeanors doesn't really seem to represent a whole lot of an expansion due to all of the exceptions that are included. So we're interested in whether the committee sees an opportunity perhaps to be more expansive with qualifying misdemeanors. And I think the last thing I just want to mention here is that we also support the retention of the provision that allows petitions for things that are no longer crime. But we also are struggling to see the value in the limitations that are placed on it. And particularly, I'm looking at those at the top of what I have as page 48. Again, I think that if we decided as a state that that there are certain things we're willing to seal, then we may want to reconsider how many years or how many hoops we want people to have to jump through in order to actually make that happen. If we see it as sealable, then it's sealable, period. So those are my very quick notes. I'm trying to get better at being concise in testimony. I hope that shows. And I thank you for your time and welcome any questions you may have.
I guess I'll start with a couple questions. If there are specific misdemeanors or felonies that you think, on the misdemeanors that are being excluded that you think should be included, we'd certainly like to hear which ones those are. And if there are additional felonies that you think should be included, would like to know that as well. So the other thing, you mentioned the ensuring people get records pertaining to them, right? How does that look? I mean, what does that look like as far as if we're going to do something in statute? I'm trying to understand. I mean, who's responsible? I mean, if it's a court record, presumably they're getting those documents. If it's records that the state's attorneys have, their defense counsel should be getting those documents. So what additional kind of protections for making sure people can get their records that you're talking about?
Yeah, we see this largely as part of a bigger comprehensive records management strategy. And so thinking about the system as a whole, there's going to be the courts, there's going to be, the state's attorney's offices, also corrections. And then also, again, if we're talking about sealing or expungement, one of the things that we had been asked in previous testimony was, well, what happens if a person wants their own records? Then what happens if they're not able to access them, if we've gotten rid of those records? And I think that one way that we can allow for that and allay that concern a little bit is, again, by just providing it as a matter of course to people before it's altered or archived or destroyed. And then that way there is at least for that person the ability to revisit if necessary. But again, really what we're talking about is just not just having it be available to people upon request, but making it more of a proactive matter of course exercise that regardless of what their touch points are, whether it's the courts, the prosecutors, the correction system, that they're getting those and that it's on us to make sure that we're proactively providing it instead of asking them to navigate a web of records requests, et cetera.
So is this an initiative that you folks are pursuing? Is this something we can look at? But it seems like that's broader than just this bill, and it's something that we could look to get set up for next session if you have some ideas that can be turned into legislation, if that's where this should be dealt with as opposed to policy.
I do think that that's something that we would be extremely excited to work with you all in another year. It doesn't have to be in this bill, but I do think that the language of this bill, of course, should maybe be finalized with consideration for the possibility that we're going to have language about a broader records management system going forward. There is language from Kentucky and from Utah. They refer to those as subject of the record statutes. And so we think that there's really strong language that we could borrow from other jurisdictions on that topic. And we'd be happy to share more with the committee about that, and also to continue consulting with our peers around the state in some of these relevant entities to make sure that we're on the right track.
Okay, great.
We're on the right track.
Just in our, the proposed language in this bill that we're looking at, on page 27, subsection 8, we have a carve out for people, their own criminal history records, and their attorney will always have access to sealed records. So we're at least protecting it in that sense. And that's at least that's.
Yeah.
Yeah, okay.
Which this raises a question. It would be interesting to get the archivist in here saying sealed records in perpetuity. I'm
Yeah.
curious what the record retentions policies are for state's attorneys, for defender general, for others, and if these records are actually not retained into perpetuity. So that we'll ask that as an archivist. Other questions for Susanna? Not seeing it right now. There's, there will be probably changes as that happens in when it comes into this committee, and certainly we'll reach out to you if you're going to want to weigh in on a subsequent version of this. So appreciate your time.
Thank you very much. Thank you.
Thank you very much for your time. All right, let's go with CRG. Is that what you talk, or do you refer to yourselves as?
We refer to ourselves as
CRG.
CRG.
Okay, all right.
You can,
It's so much like CSG.
I know people confuse us
I know,
a lot.
like,
I hear
yeah.
people say,
Also,
oh,
we
wait.
do like the same.
Yeah, we do similar things, and yeah, I've heard people,
Yeah.
but definitely call up.
Yeah.
We're local.
Oh, yeah.
Yeah, oh yeah.
We're gonna get you in at some point to go over the conditions of release report.
Oh, that'd be fabulous. Yeah, that's not what you're here. No.
Yeah, we're gonna try to get these bills out of here. before we
Yeah.
turn it back to,
Are interesting.
Yeah.
Interesting.
No, it is interesting. And
It
we'll
is
tell you,
interesting, yeah.
personal interest, we'll do the formal things.
Yes, I'll be formal.
I'll be formal. I'm Monica Weaver. I'm the executive director of the Crime Research Group.
And I'm Dr. Robin Joy. I'm the director of research.
So thank you for inviting us in to talk about S12. I'm just do a brief introduction, and then I think we'll probably get into a little bit more about how these types of records are used in research, which I think is a really important part of the conversation. I'm looking at S12 as it was passed by the Senate. I don't know if that's the one yours. Okay. So I have the one which all the strikeouts. So on page 54, number 10, that is but I don't know if that's the
The page what? Where?
page 54, because I have the one that's all the strikeouts. So it's
Oh, that one.
Yeah, anyway, so it's in the section on exceptions.
Okay, okay, yep.
C10, let's go there. C10.
What page is that?
C10 is, I think it's on page 27.
Okay, yeah, I heard a reference to a different page and realized I was like, oh, I have the wrong version of it. Okay, so section number 10, C10, really is what impacts the crime research group, but any organization, quite honestly, that might want to conduct research. And what it says is that if this bill passes, that we would be able to have access to the sealed information. And then so we want to explain to you why that's important and why we're here asking you to please make sure that you keep that part in the bill. So that's the genesis of our testimony today. But really, I'll turn it over to Robin because she's the one who actually works with these.
Yeah, so, there's a few things that I want to talk about today. One, and I am looking at this from a research perspective, so not the policy perspective of the individuals who are impacted by this, but the questions that you're going to ask me to then go answer, because research is really about looking into the past and what happened in the past, and can I accurately describe it? A few things about the way we get data, including criminal histories, but I'll start with the data that you got yesterday from Tucker on the deferreds. That came from me. And it came from the court adjudication database that I maintain that does not get the order to expunge. So those are the true numbers of people who got deferred. And I got a question from a stakeholder after his testimony. If I look at the most serious charge on the docket of all the deferreds from 2017 to 2024, 23% of them were for domestic violence. So the whole, so just to answer that question. So I have this set of data that I get monthly from the judiciary of all criminal court dispositions, of all juvenile court dispositions that doesn't get tainted by the expungements. And that's good, because then I can answer the truth of what happened, right? And I think that's important to do in research. And especially if we look at some of the things that we want to talk about disparate impact, then I still have that data, right? So that doesn't go away. The criminal histories are another data set that we use for research. And the criminal histories, I consider those to be the gold standard because they're fingerprint supported. That means that they don't have to worry about the fact that somebody's changed their name or used aliases in the system or anything like that. There's been some level of checks going through on that data, more so than what goes into some of the other systems by the time it goes into your criminal histories. And it's all the information in one spot, right? So I don't have to merge data from the judiciary and the cops to get this information. It's all in one spot. It's a data set that I can, what I do is I send a list of names and dates of birth to Director Wallen, and he then sends me back a huge XML file that I process into something that I can analyze for you quickly. So in those fields, Director Wallen did say that, he would be able to give us access to those sealed records in the extract that we get. So that is good, and we do want to keep that. We also want to say that, on the expungement versus sealing, from a research perspective, destroying government records is really just kind of, and I'm saying this, and I want to say this carefully. My grandmother survived Auschwitz, and I know this because she survived, but I also know because they kept records. And so that's the kind of thing that really just gets me scared, because even though they kept records, there's still a whole bunch of people who think it didn't happen. And so expungement from a research perspective, or for cataloging the harms that we're perpetrating on people now that we aren't aware of or that we're not conscious of, that is something that, you have the Truth and Reconciliation Commission that you guys set up, right? And they're going through all the archives and they're going through the records. So what's the next Truth and Reconciliation Committee, and what are we damaging by them not being able to have access to those records? So that's just something that I struggle with. Not the personal side of the people who are currently impacted by those records and the bad things that can happen with like the employment, et cetera, but the longer term kind of questions that the next generation may ask.
Yes, go ahead.
I mean, that's a really good point. I'm just wondering if any of the states that have expunged have been able to, like, before the record is expunged.
I've been thinking that, right. So that was part of my thinking today. Like, what do we do? Like, how do we balance this need? I think,
because there's research out of some of those states saying, here's how expungements work for the first few years. So they must have something, right?
well, so just like we had that long discussion on the definition of recidivism, right? So how people are measuring this. I think that as I was thinking it through, certainly having these records that come to the fancy name for us sometimes is the State Statistical Analysis Center. Having these records come through a statistical analysis center for safekeeping, right? To then analyze, so it's not in the official records, right? Nobody ever comes to me and says, was Monica convicted of a crime? I'm not going to tell them, and I'm going to tell them to go somewhere else, right? So I'm not the person that anyone ever comes to for that individual level behavior. So I think that that's part of, making sure that there is this other flow of information to the Statistical Analysis Center for that. I think some of the discussions that we've had over the years of annual reports of something, right? So we are putting out we are not, but hypothetically, putting out an annual report of this is how many people were, convicted of this crime, and these are their demographics, so that there's at least a paper report that, right, if you're going back 5 years, you can look at it. I don't know. I think that there is some kind of questions that I have about how do you balance that? And I think it can be done, right? I'm not saying it can't be done. I'm just saying that this is a concern that I have, that when I go to answer these questions, especially about disparate impact, are the records going to be there? And I can't use some of the fancy statistical procedures that we would be able to use in larger jurisdictions.
And so can you clarify, if any records that have been expunged already, you currently?
So I don't get them in the criminal histories. I do have them in the court adjudication database, but that's not an easy way to do that. And the reason being is that a person can appear under different names in that data set, and I don't know. Since the move to Odyssey, there's a number attached to a person now. And that may be a little bit easier. And that's on my list to talk to the judiciary about, if we can get that with our extract. And then I can come in and say, I'm okay, right? I can do this research, go ahead, burn it all down. But right now I'm not comfortable saying that.
Because I'm wondering if one of the parts of the bill ends up being honoring current expungements, is there some piece that needs to be added for research purposes, so that is there a solution that might work so that that body of data is still available, even if moving forward we're doing sealings, the people who were promised expungements having that data be available?
Yeah, I mean, I think and maybe this is also a question for the archivist about, how are we archiving systems like, on day one, right? So for example, we've heard a lot from the federal government that when the administration changes, that the websites are archived from the past, right? So that there's a record of that. So what records, there aren't snapshots of OMS that are sent
To the
Yeah.
archivist. Well, there is a snapshot of OMS, but I don't think
Okay.
the archivist gets it.
Okay.
Yeah.
Right. So like,
Yeah.
yeah, you see that. But what are those snapshots? Where do they go?
Yeah.
Which is different than, how does a person, who's just applying for a job not have the mark against them, right?
So just if we're talking kind of more like the deferred, so it sounds like you are getting those records of deferred sentences. Are you subsequently, when they complete their deferred sentence, that you're going back in and
No.
strike them? So that's not an issue as far.
So it's not an issue in that data set.
In that data set.
In that data set, yeah. But it does not come in on the criminal histories, on the rap sheets when we get them. And I didn't get a chance to listen to Director Wallen's testimony yesterday, but one of the things I was wondering if he's actually talked to you about is on what is kept in Vermont criminal histories, and then what is sent to the FBI.
Actually get into that.
Okay. It's different. The FBI actually is much more strict about what it'll take. And so there's less information that gets transmitted to the FBI, and that transmission is for the III record check. So that's so somebody over in New Hampshire can find out what's happened. That's the system that they pull from. But I think at some point that may be an interesting conversation for you guys to have.
What's the III?
You want me to know what III stands for?
Yeah.
Do you know what III stands for?
Interstate
Interstate-
Identity Index. or
Yeah, that's
something like
it.
that.
Very good.
Yeah.
Wow. Interstate Identity Index.
Identity Index.
Yes, Interstate Identity Index.
I know something.
Yes. That was very good.
Thank you.
Yeah, that was impressive. Yeah, yeah. And so because it's right, these records don't just stay here.
And there's nothing we could do once they go to FBI, is
They all-
telling them to seal or expunge it?
No, you can talk to Director Wallen about that. So my understanding is that they will send something to III. Or how it all works. I mean, so the technology behind the III stuff is difficult. I think is the way I'm going to put that. So Director Wallen is the best person though to describe all of that. And then also like, well, what happens? Does the fingerprint card get destroyed if there's no prosecution? And when does he destroy that fingerprint card? And that's different than the fingerprint card that the cops have, right? So those kind of procedural, the walking through of how that criminal history gets created, and then where it gets transmitted to, I think would be a very interesting. I'm always for everyone understanding how the data gets into the system. That's it.
That's
So I don't have too much for you guys.
So the main thing is that you don't want our subdivision C10 on page 27 to go away.
To go
We don't
away.
want it to go away.
We don't want it to go away, and to think about the research
Yes.
questions that other people will be asking or that you will be asking of me, and really making sure that I'm able to answer those questions.
How do we know what we're going to be asking in the future?
Well, just meditate on it,
Yeah.
you know.
So what do you
Reviews
need
your
here?
information.
Yeah.
What do you need here to help us define recidivism?
Good one. That's a good one.
Yeah, I mean, these are really interesting questions, and again, just to be able to preserve the ability to do research and to explain what we as a government have done to human beings here. So
I appreciate that.
yeah.
But to relate to your question, criminal history information would be, as Robin said, the gold standard. That would be the gold standard
Yeah.
way to actually measure recidivism. And so
Yes.
that would be, there is a relationship.
There is a relationship there,
Yeah.
yes. Yeah.
I mean, the other question we probably want to be asking, whoever we are in the future, is did sealing have a positive or negative impact on the people who benefited from it? Like, so is it helping to relieve collateral consequences? And are people
Sure, here's
recidivating by
here's
whatever
how-
definition? we-
Yeah, here's how I would have to answer that question. So I'm just going to tell you how I'd answer the question now. We would need to know the names and dates of birth of people who were sealed. We would get that information because as researchers, we're entitled to doing that. And then we've been working with the Department of Labor to see what kind of data we can get from them. And so then although we don't have that agreement yet, we're getting there. I would then take the names and dates of birth, send those over to the Department of Labor and see who had employment counts over the Department of Labor. Then we would lose some folks, we would lose the under the table folks and things like that, but we would get some employment counts. I would compare that to the same group of people who may have been eligible for sealing prior, because I have all the records and do that. So that's how I do that.
So we understand that there's quite a few, there's 2005, I guess, cases were sealed last year. Is that what the?
I think that's what it is.
Yeah, I would ask for the definition of a case versus charges, because sometimes charges or cases
I don't know if it was case or
It was
charges.
charges.
It was charges, okay.
Because that's why you had such a huge number of expungements, because it was charges that were being dropped.
Oh.
Yeah, because their data system is the way I see their data system is at a
It's by
charge
charge.
level, right?
So there's data now that we could do, or you possibly be able to do some baseline.
Yes.
We could look in some number of years. How do we get you to, I mean, I don't know if we put into a bill that we want this report in 5 years or whatever, because it can't, well, I mean, it can't be like right now because we need to see how it works. But
Right, so
There's a lot, yeah. Well, part of that is one, we hope to be getting the agreement, the MOU with the Department of Labor. We don't have that yet, we're still, that's related.
or
to-
a sense, that's related to
it's
the Act
related to
40.
Act 40,
Yeah,
because they are one of the entities that is asked to give us data in Act 40. And so we've been working on that. We didn't need it for the first part. So, or we couldn't get to it at that point.
so do we,
And then the second section is resources for us to be able to actually do a study like that. That's not like a quick data request.
Yeah.
It's not,
And I think also I would like to work with stakeholders. And so, okay, so the Department of Labor, right, that's easy. It's an easy metric, right? Somebody is employed, somebody has been paying taxes, and, you know, that's just a metric. It doesn't address housing, right? So another reason for this is so that people aren't discriminated in housing. We don't even have a definition. We don't have a shared definition at all of what stable housing is. And so, right, there's a lot of groundwork that would need to be done. The Department of Labor is of convenience, because we don't have any, you know, nobody's keeping a registry of all our housing, right?
right.
No.
And
So,
looking at the other
Yeah.
collateral consequences, licenses, whatever.
Licenses we could do, yeah.
There's, yeah, I mean, we'd have to go through the.
yeah, so I mean,
really see
what we are trying to do when
Yeah.
we, as much as we can, is when we're looking at passing bills, is having some sort of check and see if it's working.
And this one's tricky.
Yeah, and I don't know that you would even see results in 5 years, right?
Right.
Um,
What is even the result that you're looking?
Well, that's the question. I mean, so how many lives, how many people are able to get housing and jobs because they don't have a criminal record? Because we are expanding the number of offenses that people can.
Okay.
It's
You can see that.
I think you could do it and say like how many crimes are being hidden from employers' housing, da, da, da. That is expanding.
Yeah.
well, I mean, I think you'd have to do a qualitative analysis, but then you'd
Yeah.
also, I mean, just the realities of Vermont. How many people aren't getting housing generally, right? And so we're in a housing crunch, so are we gonna see, you're gonna expunge these, and is it without any more housing, like there's a limited amount of housing that people are gonna get. Do you know what I'm saying?
Right.
So it's hard to kind of look at and say, okay, well, we have an increase of, you know, we can't look at a decrease, right? So if people are able to increase their ability to get housing, we would expect to see a decrease in the rental rates, right? Which we're not gonna, I mean, we can't get much lower than we are for the rental vacancies.
Where would you get a reliable data center where somebody lives?
You
Yeah,
can't,
you
you
can't.
can't. You can't. So that's why I'm saying, like, so what statistical measures, population level measures we would look at? You would look at the vacancy rates, which are already where they shouldn't be. You might look at the annual homeless count. But again, what other things are going to be impacting that annual census?
crime rate.
You could essentially be homeless and have an address, so.
Yeah, oh, I know, but I'm talking about the annual census that they do of people who are unhoused and on the street that night.
The other thing, Rob and I have these conversations is, you know, sometimes a policy is just a good policy.
Right.
And you don't need to go through, not that I want to be the person up here to say you don't need to fund like some extensive research project for it. But sometimes
Right.
you do it just because it's a good policy.
Maybe sometimes it's
Yeah.
harder to measure.
Yes,
than
right.
others.
Yeah.
You won't know it until it happens.
I mean, I feel like for me, it is the total number of convictions or charges and convictions that are sealed or expunged. Like currently, and then 5 years from now, hopefully we will see that number increases. Like that will be measurable, right?
That's a measurable thing. It tells you how much happened.
Yeah.
Right. It
Doesn't tell you whether.
doesn't tell you whether or not anyone's better off or if
Yeah.
they've had.
Or if there's even, yeah, I mean, I think the other question is
Yeah.
where's there a disparity in who's accessing the expungements and sealings?
That would be
That's
Yeah,
kind of
that would
the
be-
question, that I think I would have is how do you make sure that everyone is accessing it? Everyone has the same equal access.
Mm,
That would be something that could be,
Yes.
that would be something that could be studied.
So presumably we can, ask the court to report to us annually on the numbers.
Yes.
Raw numbers. I don't know if the court is able to, I know they'd be able to, but how easily to break it down by county. We can talk to Judge Zone further about that. Because they really quickly.
Yeah, they got that. Yeah, I was really impressed. Yeah.
Very good.
Yeah.
So we can actually, so we're actually getting that information. We can ask for that report from the court. So maybe that's what we do, at least initially.
Yeah.
Yeah.
And then maybe we put a sunset on this in 10 years so that people can come back and decide if it was a good idea.
That was a joke. I
So with more accurate information, I got recidivism rates on my mind. More accurate information, our recidivism information is gonna be more accurate.
Right.
Because now with expunged,
Right.
time,
So, for
it's
example,
not accurate for Vermont.
correct.
So what goes through my mind with that is if our recidivism rates or information is accurate or much more accurate, then that information can come back to us as far as guiding us toward policy, which is going to be better for Vermonters.
Sure. So there's a few things. So like if you were to, don't do it this session, but if you were to adopt an official definition of recidivism and we worked all that out, right? And like the Department of Corrections is currently doing, every year they post a new thing, right? Those folks that they're talking about in their recidivism definition, right? So everyone who's been sentenced to a year or more and then reoffended within 3 years, those folks, their stuff isn't getting expunged by the time they make the calculation, right? It's not going to be expunged by the time you make the calculation. When I did the diversion evaluation, so I evaluated your diversion program. So that was going back in history, right? And there were about 400 folks who I couldn't find a criminal history for, probably because they were expunged and then never, and I had to make that assumption that they were expunged and never reoffended in Vermont. And that's a pretty good assumption because of the group of people that you're helping in diversion. First-time offenders is right. This means that they were a first-time offender. And that diversion worked. They got their DLS sorted out or something like that. If you want me to go back and look at 10 years from now, how how the retail theft stuff did, then that may, right?
Right, at some point. And this is setting us up for that future of wonderful.
Right. And that's the thing I can't get around statistically. In larger volume states, we could get around statistically and say we expect that X% of these are actually expunged and so on. We can't do that kind of fancy math here.
I really appreciate the testimony today. And
Yeah.
as I am a new legislator and I'm sort of wading into this discussion around sealing and expungement, I'm trying to getting my hands around it.
Yeah.
And I appreciate your family story because it's something I was thinking about. And I think and I'm going to try to make this a question, not just testimony. I think what I'm struggling with is, and I'm curious your thoughts on, the balance of a subset of this data are people who are harmed and the existence of the record is contributing to the harm.
Yes.
And that we as a government should strive for doing as little harm as can, I think, and to achieve justice. And so your long-term view of that goal requires as much data as possible, but our short-term goal in achieving that end may require or hope should maybe eliminate that record to do as little harm as possible. And I think that's the balance.
I think there is, it's a balance. And I think technologically we can find that balance so that the people are not harmed, but that the research can still continue and is preserved any harm that we may be doing that we're not aware of, right? That's really the stuff that I'm kind of concerned about is the harm that we're doing that we're not quite aware of yet. And that future Truth and Reconciliation Committee, do they have the data that they need to answer those questions? And so I think that there is a way to make sure that people are not continually harmed by this, and that we can still make sure that any disparities are covered, are not deleted away.
Yeah. Yeah.
You don't want to delete the racism away.
Yeah. No, and that makes a lot of sense to me. I appreciate it.
Great. Thank you very much.
Yeah, sure. My pleasure.
But before we break, I just kind of want to run through, I'm going to suggest some changes for Michelle to start kind of working on. The additional witnesses we have are kind of specific to like DCF. And I mean, we still need to hear a little more from Kim McManus, and we'll hear from her this afternoon. But let me just run through these things and see if folks are generally okay, at least for looking at it on the next draft. Doesn't mean that that's where we'll end up, but I'm gonna suggest we add assault of a law enforcement officer. I think it's broader than that, to the list of not expungible misdemeanors. That, I mean, I'll look around, get nods or objections. I was going to
Fundable or sealed?
seal. Thank you.
Depends on the definition of expungable.
Well, seal. That's seal.
Or before you go there,
Yes.
maybe figure out, are people gonna have are law enforcement gonna have access to the sealed records like they do now?
Right. So I'm going to that one next.
Well, but I meant,
Oh,
before you
add-
decide to add one that you
Right.
just can't seal, because you want to make sure that when someone's knocking on a door, that they can look and find a record. If they're already able to do that with a sealed record, then I wouldn't want to,
Nice point.
Yeah.
Okay. So hold that one in the babies.
yeah.
Right.
Yeah, because I also want to hear if other people have more examples of what they want to have sealable.
Right, because we're
And
gonna
if
have
there are ones that we shouldn't.
firefighters,
Yeah.
EMT,
So-
we're gonna have
So,
string of
Um,
people that we want.
so on page 25, so the use act versus access. I wanted to have, Michelle try to do something where we're not putting restrictions on access or use unless the document's going to be used in court or in some public manner. I mean, because of what we heard from Zone A, I know that that's not in line with what Marshall wanted to talk about. But and from what we've heard from law enforcement, I just don't, I think I don't know that it does much, and it's a lot of confusion, a lot of vagueness. So that's what I'm gonna ask her to do. Are people fine with that concept?
Like to know his opinion. Sorry, I was trying to get some information.
So taking away the requirement of a petition for use for criminal justice purposes, unless it's going to be used publicly, which means really in court, like we can make it a little bit broader, if it's going to be used in some manner publicly or in court. We'll try to have Michelle work on some language to that.
Not being able to use
No.
it unless it is going
Unless
public.
it's
And then
going
we have
public,
to
then
petition
then
the
there's a
court.
petition.
At that point, you're gonna be contacting and talking to the court about it, I'm assuming, so long as that occurs,
Right.
yeah, whatever.
So I mean, it's.
I mean,
So you're,
I know that, I know, well, no, I know, we talked
See how
about
Michelle
this, and
drafts
the concept is that it would happen in a matter of course anyway.
Right.
But frankly, I think we need to have something in here to get this through. You know, and I'm trying to narrow the restrictions that we're dealing with here. I mean, I don't think we were going to be able to get it all the way through with the Senate if we just simply say you can use it, with no restrictions at all. The only one, again, is if it's going to be public or in court.
well, when I see it, I'm just looking at a sealed record of conviction. I'm not looking at necessarily the person history or anything else. It's that one incident.
can you see what the conviction was?
Well, I don't know. It depends if because it could be charged one way and come back from the court the other way. And I don't know, some places don't always put the ultimate resolution into the Valcourt case. Was it a simple assault and then became a disorderly conduct? I may not even know that. That's why we don't really take a whole lot of
Wait to,
what we're looking at right there. And here's the other thing too. I mean, there's person information in there and things like that. If they were charged with assault on a police officer, that's one thing. But we might know, and in another area under that person, there could be a little flag blinking right there that says place with law enforcement.
and that's just a note that was,
Exactly. It has nothing to do with the case or anything like that. So I'm not overly concerned about that.
Tom, what if that note contains HIPAA
It
sensitive?
won't contain anything other than fights with law enforcement.
Okay. Right,
There's all kinds of other little flags and notes in there for us to be aware of when dealing with such people. But it won't necessarily be.
Mean anything.
are those notes pre-generated, or are they like in the sense there's like a drop down of a bunch that you can click
You
to add
can
in,
drop down or you can type.
or you can type in your own? If you see a,
That it would happen independent of the case.
yeah. If you see a sealed record, would you see if it was sealed because it was, like acquitted, or like, do you see what the
Honestly, I
resolution?
can't ever remember reading one that deep in depth.
Yeah,
In fact, I don't remember the last time I saw a sealed record about court. I mean, you find them, but
Right, so it's not.
it doesn't seem like it's,
I'm more looking at the generality of the person's contact with law enforcement more than I am anything specific. Sometimes you're looking specific if you're trying to solve.
And
So we'll try that, what I'm just saying, and we can have further discussion, certainly, but I am trying to narrow the restrictions on the use and access by criminal justice agencies, which would also, in my view, that we wouldn't need subdivision C3, the whole exigent circumstances part. If I don't think that exigent circumstances is to get around having to do the petition.
Yeah.
And if we're saying you don't need the petition, so we can see how that flies. I doubt that the Senate would like that, but.
to the Senate, like, were they talking about sort of investigations, or were they really focused on use?
I have no idea.
Yeah, okay.
I don't know.
speak
I think
legislating.
I'm not really bothered by that.
Yeah,
I know I was out a bit, but you're in that section on page 27. Number 10. Did you already talk about the 10-year limitation? Oh, is that from last year's bill?
yeah,
So we can get rid of that.
yeah. They didn't even give our 10-year super seal.
Oh, but you said, right, okay.
Right, they should.
Yeah.
Super.
I would say good
Brought
catch,
to you by super glue.
great catch.
Mm.
So, and we have to also figure out the sealed records in perpetuity. We do need to bring in an archivist to talk a little bit about retention policies. I should have asked you, do you guys know much about retention policies?
We have our own for the organization, that's.
Yeah, but as far as like the state's attorneys or the.
No, you'd have to ask them, yeah.
Okay. Good. Let's see, the other thing, I had a couple other things. We should consider and think about on page 31, the going to a petition procedure. That's something to ask, I think, other witnesses. I'm not going to suggest that we do anything in that at this point. I would like to also add deferred sentences and sealing deferred sentences back.
If they're not already deferred and expunged.
Right, unless, yeah, but honoring the current expungement ones. And I'm thinking about seeing, asking for a annual court report.
You don't like that?
Ooh.
Ian, I think there's the one, like, yeah, right. It's,
On the annual report, I was thinking in regards to what Representative Dolan was asking, I think you want to know how many individuals, not how many charges, right? Because the charges can be, and I can work up probably a better research question when I get back, but I think the question is, how many individuals had the entirety of all charges dismissed, all charges sealed? So like all charges, what we look at is we look at all charges disposed of on the same day in the same county. That's how we kind of define a disposition case. And then we would look at how many people had all those charges. Do you understand what I'm trying to, defense attorney person?
I'm not quite there.
Okay, so I think that's really what you want to know. It is not helpful to know that Joey got, a case sealed, a charge sealed, but he had 3 other convictions, right, that day. So what you want to know is how many people had all of the charges sealed that were disposed of on that day. I think that's the question.
I don't know about, I was just looking at the total number of sealed and expunged in general. Because I see that as removing barriers.
But you may not be removing barriers, is what I'm saying. Because if I still have 2 other charges on the docket that aren't sealed, you remove no barriers for me. You just removed that one thing, right? There's still those 2 other charges that I got convicted on or something else.
I feel like that could be yes and no, right? Because who knows what those charges are and how somebody would look at it. So I agree.
It might not be a sealable charge.
Yeah.
Yeah, so I guess the question will be what the court can give us. 'Cause I don't wanna. Yeah, if they can give us that
Do
information.
we do a lot of deferred sentences on sealable charges?
Well, they're all,
Deferred sentences, so a deferred sentence results in an expungement.
Right,
So
so,
there isn't, it's like kind of, you can't really have a sealable.
right,
Yeah, it's gonna go away. Yeah.
Deferred sentences?
Yeah, that's like the nature of a deferred sentence right now is that at the end, it's expunged.
Well, maybe we can do a sunset on that with some data and look at. So do they really go away?
you have another,
Definition
of recidivism.
And do we want to look into if somebody is charged as an adult? But they're a youth. If we want anything different to happen for sealing. So for somebody who they're gonna end up going to criminal
I'm not sure I understand.
or youth following the exact same sealing law, or do we want to have anything? Do we want them to have to wait 10 years?
You gotta follow the rules of where the conviction takes place.
So is that getting into the section 7609, that's sealing criminal history records of a person 18 to 21 years of age?
Right.
So I mean, I don't know.
Which
We haven't had much testimony.
I
on that
know, and
section. We'll ask him to weigh in on that a little bit more.
It's interesting, Marshall, I was not here for all of
Well,
Marshall.
he did, yeah, no, he did. He
Okay.
said that
I'll have to-
changing from the being automatic expungement to a petition seal. He didn't like that. Anything else, at least at this point? That's what I'm gonna suggest at this point for some changes.
That sounds good.
Good, all right. All right, so we're adjourned until, I think it's gonna be an exceptionally short floor, depending on how many announcements there are. Nothing on the action calendar, because what's on the action calendar, what's that?
Isn't it your birthday?
No.
Whose birthday is it?
Is it your
No, no.
It's your birthday?
Second.
I'm not joining this out.
What kind of rumors are you starting? I don't want to turn 62 for at least a few more months.
That's
So
I don't even remember.
So we have people coming in at 1:30 and we have, we're gonna do a S87 and hopefully get it ready to move tomorrow, hopefully.
Extradition?
The extradition, ready
Oh,
to
yeah.
extradite that bill from this room. And then we'll probably, I'm trying to get, since Kim will be here, I'm gonna